Well, let's ask the other panelists about that. You're suggesting that the state laws we have, the patchwork of the state laws we've had, are not adequate, that we need federal regulation to begin with, to be followed by adequate state regulation. Is that right?
Well, Mr. Chairman, if I might address that question, I believe the Senator's question may have also been instigated by something in my testimony where I did, at least on the STOLI level, allude to perhaps banning it at the federal level. But I must admit that statement is born somewhat of frustration and the difficulty we've had in Florida in passing what we consider at the Office of Insurance Regulation an adequate biatical or life settlement law. In fact, as I stated in my written testimony, the office introduced the bill to enhance both the reporting, the disclosures, strictly on the biatical or life settlement side, plus the measures to address STOLI. And the industry came back with, did not support us in that effort, hired lobbyists, and came back, in fact, with an alternative draft that was put forth as being an adequate STOLI bill, but in fact, if you read it very carefully, gutted what we were even doing, that little that we were able to do. So I would suggest that, that there has been some difficulty at the state level. And so if the states were aware and industry were aware that Congress, yes, you really are interested in this, and that perhaps a few years down the road, if the states have not been able to adopt the NAIC model, for example, across the board to adequately protect consumers from some of these issues, then I think that that would be fair warning.
Yes, Mr.